Thank you for being here with us today in another training. We have two Allison with us today. We have Allison Packard. She's a law, you have a law firm in San Antonio, I think. Miss Allison Packard, thank you for being here. And we have again, Miss Allison Schaberg. She's from Consolidated Planning Group, and they're going to be talking about the difference of why do I need a special needs attorney and a special needs financial planner. What are the difference? What do we need both when we have a kid with a disability? So thank you guys. But before we start our presentation, we are going to talk about Partner Resource Network. My name is Veronica Alvarez, and I'm the Regional 13 Coordinator for Partner Resource Network. So I'm in Austin, and welcome. Let me share my screen very quick. All right, let me see. All right. Partners Resource Network is the parent training and information centers for Texas. We are funded by the Department of Education, Office of Special Education, and we provide free resources and training for parents with children with disabilities and youth with disabilities. Our mission is to empower and support Texas families and individuals impacted with disabilities or special healthcare needs. We serve parents of children with disabilities and youth with disabilities from the ages from 0 to 26 years old. Partner Resource Network was first founded in 1986. And now we have 4 projects serving parents here in Texas because Texas is so big. That's why we have these different projects, different directors, but we are the same family. Partner Resource Network is the same company. We just have different kind of names. But if you really not need to connect with a coordinator near to you, please just put it in the chat box and I can tell you who is. So I'm here in Austin and I help parents here in 13, but we have, you know, in each area, a coordinator helping parents. And also I'm part of the team project in the red area in the map. Our services are free and we offer parent workshops, youth workshops, webinars, because COVID right now, everything is online. But we have also information and referrals for you. We do a technical assistance, one-on-one phone calls or video conferences. We help you with the IEP preparation, so we can go with you to the R meetings. We do once a year a symposium, each of us, each coordinator. So we have 20 coordinators making a lot of training for you guys. And we do also parent leadership trainings and youth leadership trainings. In our emails, you can receive more information of these events going on all over Texas. We do these things. So for today, if you have a question, please type it in the chat box. Your microphone and your video is off, but you can talk to us, type it, and we will try to answer your questions. This webinar is being recorded. Later on, we're going to post it in our Facebook page, and also Consolidated Planning Group. Alison has a YouTube channel. In the chat box, you have that information. She is going to also post the video later on. At the end of this presentation, you are going to receive a survey link with an evaluation. Please help us with that. With that information, we report back to our grant and we can continue to give you guys free resources and working for you for free. So help us with that little piece. It's just 1-2 minutes and you can help us with that evaluation. We do not provide CEUs, but if you need a certificate of attendance, of course, I can make one for you. Just type it in the chat box and I can do that. So again, my name is Veronica Alvarez, and as you can see, there is my contact information, my phone number, my email, our main webpage, www.prntexas.org, with a lot of information about disability, special education, everything related of special healthcare needs. And done. So now I'm going to stop my sharing. Can you stop it, Allison, because I have the
yes, it's okay, I think.
Yeah, I have the live transcript. Okay.
How's that? Can you see that full screen?
I can see great. Yeah.
Okay, wonderful. Veronica, thank you. As always, it's a pleasure to be back with you and Partners Resource Network. And thank you for doing all that you do. You guys do so much education, so much client education out there. And it's nice for sure to be able to get you know, to be able to get the resources and tools and resources that we need for free. So that's nice to be educated for sure. So Allison Schaberg, back with you again from Consolidated Planning Group. Consolidated Planning Group is a holistic special needs financial planning firm. We've talked and partnered with Partners Resource Network many, many times on a variety of topics. And so while we are a special needs planning firm, we also pride ourselves in providing a lot of free educational topics surrounding special needs planning, transitioning, those types of things. So I would like to say first that we're definitely glad you're here and that we are very hopeful that this hour of your time is going to be very well worth it. We really try to pack a lot of information into these webinars in a short period of time and answer as many questions as we can. So as she said, please put your questions in the chat box. We may talk about topics or dance around some other topics today, kind of surrounding the special needs community. And I call them buzzwords, things that we always hear in the special needs community. And what you should know is that basically all of these topics go deep and wide, right? So each of these topics can, should, and do have their own webinar dedicated to that specific topic. And those all live on our YouTube channel. So if you've missed them in the past, they're out there. If you've missed them in the past and want to attend live, they'll be happening. We have monthly events out there. So I am excited to be back with Alison Packard. So there's the debate, Allison, on whether it's 2 L's or 1 L and which one is the right spelling. But anyway, we'll let you guys decide that. But I had the pleasure of working with Allison through the Texas Partners in Policymaking. We're both selected for that program last year, and we spent 9 months in a very, very extensive program. And really, how do we get the law changed, and how do we look at things, and how do we advocate for our families and loved ones with special needs, and getting policy change, law change, things, community change, things like that. So it was certainly my pleasure in partnering with Allison in that group, but it's certainly also been my pleasure and sending referrals to Allison and her law firm. So today, the topic that we're really talking about today is why do you need a special needs financial planner, and why do you need a special needs attorney? And so, as always, I'm going to let you do the disclaimer, Allison, because I know you have to do that.
Yeah, I do. And before I say that, I want to thank you both for the invitation. I have so much respect for Veronica, all that you do, and Allison, all that you do. Such a benefit to the special needs community. And so it's a true honor to be here with you. But this is the legal mumbo jumbo that lawyers always say. The fact that I'm here is not creating an attorney-client relationship. Everything we're talking about is for educational purposes only. And so you're not hiring me by listening to me. But, you know, I do encourage everyone to talk to your own special needs attorney. Every situation is a little different. And so even though we're going to talk in general concepts, your particular situation might have a tweak that changes the legal advice that you would get. So that's it for the legal disclaimer.
Yes. And, you know, for sure, I call them the stump the chump questions that every week, for lack of a better term, every week there's always something. There's a one-off. My family situation and kids, there's one-offs as it relates to all things that matter, SSI related, those types of things. And so everybody's situation is very, very unique. So I'm definitely glad that you brought that up. So the truth is that Allison on a pretty regular basis gets calls and asking her if she can open an ABLE account or if she can handle financial matters. And we get calls every week on if we can open up, can we represent somebody in guardianship, or can we create a special needs trust for somebody? So there's a lot of confusion in this community on the hats that each of us wear and why you might need both of us. So a special needs financial advisor is going to provide financial advice with special needs considerations factored in. And plain and simply, attorneys provide the legal advice. So I like to summarize this and say that they're the paper and we're the money. So the paper matters. The legal documents matter. That those documents like wills and trust, special needs trust, first party, third party, guardianship, power of attorney, healthcare power of attorney, HIPAA release, all of those documents, think legal documents, and you're going to think on the legal side of the house. And where the money is, the money in the right bucket. So a lot of things don't matter financially for a long period of time, 18 years that you have this loved one growing up. Maybe you didn't qualify for SSI and Medicaid. It didn't really matter. You didn't anticipate them qualifying in the future, but everything changes when they turn 18. And so a special needs financial advisor has basically the same licenses that a traditional financial advisor has. However, they also have other additional certifications and licenses and associations, like, for instance, we're nationally certified as Social Security advisors. So that's, special classes and coursework that we've taken. We have specialized software that helps people with those calculations, and we'll talk more about that in a little bit. But what I want to talk about is the attorneys, because Miss Allison, all attorneys are not created equally. And so I'm never, ever being insulting at all when I say that. But what I would like to say is your situation is specialized. You have a special needs child that may or may not need care. We don't always know for the rest of their life, not just yours. And so careful planning and careful consideration has to go into that. So that way we can reach those goals and have enough money funding the trust and those types of things. But when I say all attorneys are not created equally, there are some attorneys out there that are very generalist. They do a lot of generalized work. So when you have a specialized situation, what my suggestion is not to do a DIY, do it yourself when it comes to some of these things. And I also suggest working with a specific attorney that is nuanced in special needs, and they have the understanding and understanding of why you need to preserve, state and federally funded benefits. Allison, you want to talk about that a little bit?
Sure. Let me just elaborate a little bit as far as the specialized attorney. Yeah, you definitely don't want to go to just any attorney to have help in this area. Every single month, I'm reviewing special needs trusts that were done by an attorney who has created them incorrectly, perhaps put a Medicaid payback in a trust when it wasn't necessary. And it's just too important to get this right. I'm also the parent of a 27-year-old daughter with very significant special needs. And I get it from the parent's perspective. When we think about us being gone, we want to make sure everything is in place in the right way. And so if you come to an attorney, what we do is, we give you legal advice and help with the legal work, whether it's a guardianship in the court or a less restrictive alternative, such as a power of attorney, or as we were talking about, the wills and the special needs trusts. And so what I would do with the special needs trust is what Allison was talking about. We'd look at the government benefits that are out there. You know, what is your child receiving currently as far as government benefits? Is it SSI? Is it Medicaid? What do we think they'll be receiving down the road? Perhaps childhood disability benefits from a parent's work record, perhaps Medicare, likely a Medicaid waiver program. So we analyze all of those programs and figure out what the right type of trust would be. And then once we've decided, yes, you need a special needs trust, we'll talk about how you want that trust to be drafted. What do you want the trust money to be spent on, or what do you want it not to be spent on? And as we look at that, we can come up with a pretty good trust document. And then I know Allison already spoke about this, but I always get asked this question, you know, how much money needs to be in there? How do I know where the money should come from? And that's where the financial planner really is hugely important. And so that's where I would refer you to Allison or your own financial planner, but you want to use someone who does have an understanding of these special needs issues. As Allison mentioned, it's, you know, you've got to make sure someone understands government programs when they're giving you financial advice. You also want to talk to a planner who understands that retirement accounts they're paying into a special needs trust are different than your typical trust. And so those kinds of issues that's why we work so well together, because there's just areas of expertise that Allison has that I don't have, and then hopefully I'll add my own expertise. I think that was a detour of what you asked me about, but as far as the government—
No, I think it's perfect.
Okay. I was just going to elaborate on government benefits. Did you want to get into that specifically?
Yeah, I think we'll talk about that a little bit further. I think one of the things that you hit on that I wanted to touch on is the future care cost estimate. Every week we have people coming to us saying, hey, you know, I have a financial advisor. I've had one for many, many years. They have, I'd say less than 50% actually have a financial plan. A lot of people have a financial advisor. And quite honestly, their financial advisors have not done an overall financial plan. All people really should have a financial plan. And that's saying you don't have a special needs child, because we're going to spend 25 to 35 years in retirement. That's a very long time to basically not have more money coming in, like our earnings and things like that. So we're going to be relying on 401ks, 403bs, pensions if we have them. Pensions are a fleeting thing of the past. Some people still have them, but a lot of people do not. But so that's, one side of the house. And that's if you don't have a special needs child of, are we going to run out of money? When can we retire? What are the comforts that we can enjoy in retirement? Can we retire the way that we want to? That's the first side. So typical financial advisors, if they've done a financial plan, you may have those numbers. But what we see is missing every single time is the future care cost estimate for your loved one with special needs that has care needs for the rest of their life, not just yours, because that's like a third retirement almost, right? A third bucket of 25 to 35 years. Realistically, that could be. So we're able to do those comprehensive financial plans that include the special care cost estimate. But we're also able to complement, if you already have your total financial plan that doesn't include that, we're able to complement it and create those as well. Veronica, do we have a question?
Yes, we have the first question. He says, how according to you, disabled young people can reach financial independence and freedom? It's in the Q&A.
Allison, do you want to take that?
Yes. So as far as, reaching financial independence and freedom, so, there's a push-pull in that regard, right? So the push-pull is how do I maintain my eligibility for Medicaid, right? And not have more than $2,000 assets in my name. And the reality is, and this is something that special needs advisors can help you with. There's multiple places that you can have money. Those multiple places are ABLE accounts, and we have entire presentations on 529A for ABLE. But basically, you can add up to $16,000 a year into an ABLE account. That's one way. And you never want that account to be over $100,000, and we get more into that in the details of an ABLE account presentation. But of course, you can also have money in a special needs trust. You want to comment on that as well, Allison?
Sure. Yeah. You know, for a lot of our kids, if they're on some kind of government program, you know, the current payment for SSI this year is $841 a month maximum. Obviously, if it's Social Security disability, there are going to be different numbers depending on your situation. But, you know, my daughter, I don't want her having to live on $841 a month. And I know that as parents, you know, we're concerned about that. And so the Special Needs Trust allows us to leave some extra money for the benefit of our children on these programs where they can access that money. I say they can access, a trustee will manage it for them, but can pay for things so they have a higher quality of life. They can have access to more, you know, opportunities and be able to spend money that makes their life better. And so the Special Needs Trust, it's critical that it's drafted correctly. If you just use a regular type of trust, then all of the money in that trust fund will count as our children's money, our children who are on disability programs, and it could disqualify them from the programs. But if you use a Special Needs Trust, that provides extra funds to pay for their care. And let me just say, depending on your situation, this again is why it's so individually planned. It might be that your child is not going to be able to work and you need to fully fund a Special Needs Trust to provide that support. Maybe your child is able to work, and that's where you would want to look into different programs that would allow your children to possibly earn some extra money on their own as they get older. There are many work incentive programs for our kids who've been on SSI but are now able to work. They can earn quite a bit of money and still keep their Medicaid benefits. So that's another whole program of getting into those details, but very individually planned on what would work best for each of our kids.
And we do have...
We have a question.
Go ahead.
It's very related to the same things that we are talking and discussing. What is the maximum amount that you can place in a special need trust and how it could be used for? That's a very common question that we have.
Great question. Yeah, great question. There's no limit on a special needs trust. You could fund that with any amount of money. And there's different types of special needs trusts, and we may or may not get into that detail, but a first party special needs trust, the funds that are in that trust account when the individual disabilities dies may need to be repaid to Medicaid. And so there may be some reasons you wouldn't want to fund that type of trust with a huge amount of money. A third party trust, you would set up where the remaining funds could go to a sibling, to, you know, wherever you want it to go, the beneficiary's own children, a charity, and there's no limit on that. An ABLE account is different. An ABLE account, there's a limit of 100,000 for people who are receiving SSI. The limit is higher if you're receiving Medicaid only, but I don't see any reason why any of us want an ABLE account with that kind of money in it, because the Medicaid payback is also attached to an ABLE account. So there's no.
I agree with that 100%. We get calls on a regular basis of, I read I could put $500,000 in an ABLE account. Why do I need a special needs trust? And you can, as long as you understand you're going to disqualify from SSI and Medicaid. So basically, not one penny over $100,000 can live in the ABLE account. And the key thing is to know it's only $16,000 a year. You can put in. Now, if the individual is working, there is an additional $12,880 that can go into that special needs trust. And one thing I wanted to mention, Allison, is a lot of times, clearly, you can be affluent and have lots of money left over post-retirement that you're going to fund the trust. Many people fund their trust with $5 or something small, and that trust is going to be funded upon their death, and it's funded with remaining assets in their estate. It's funded with proceeds from life insurance, but the trust is directly the beneficiary. And so that's how a lot of people do that. And I saw a question that said, how do we find a special needs advisor? And the answer, unfortunately, is it's very difficult because they're very few and far between. There's not very many special needs planning organizations. Our organization, Consolidated Planning Group, is 100% dedicated to special needs and special needs planning. We are members of the Special Needs Planning Academy and also nationally certified as Social Security advisors. We do work all across the United States. We are domiciled in Texas. We work all over the state of Texas, but we have clients all scattered throughout the United States. And if you're in a specific area and you're really looking for a face-to-face person to sit down with in your area, you can reach out and we're happy to make a referral. And that's true of attorneys as well. Now, Allison's firm is in the San Antonio area. And now, is it true, Allison, that like from an area perspective, I know that there's been a lot of Zoom happening. I think that you do need an attorney in your specific area if you're looking for guardianship, like your specific county. Is that correct, or do you work multiple counties?
I do work multiple counties in the court system, but I would say I'm in my county most often, in the surrounding counties to Bexar County. I do go, an hour or two away, but I do charge a travel fee. And if it's a county I'm really not familiar with, excuse me, if I'm not familiar with that county, I would certainly refer you to talk to a local attorney. Every county handles guardianship just a little differently. So if you're totally unfamiliar with the way that particular court manages the guardianship docket, it might put you at a disadvantage as an attorney. So I just sort of see what county someone's in. And if it's somewhere that I'm not familiar with, or the travel expenses would be too high, then I would always encourage you to, talk to a local attorney. But as far as trust drafting and things like that, you don't need to be county specific or even in that area. In other words, we can help people all over Texas.
Yes, for sure. And we're happy to provide, additional referrals for your areas. We have, folks that we've worked closely with for years that we know and trust. We know that they do a good job. We know their prices are reasonable. They, have a connection to special needs. So we're certainly happy to make those referrals. We have a good question here from Sue. I typically don't say the names just for privacy. If applying for benefits and a son has $2,400 in an UTMA, is that included as a resource? He personally does not have access to the account. And the answer is yes, when it turns over to him. An UTMA and an UGMA account, we don't see those very often. There's still a few of them out there. But UTMA and UGMAs become the individual's asset. I don't remember if it's 18 or 21, but it does become their asset. So the options are to move that asset into an ABLE account or to a special needs trust, or alternatively, withdraw those assets and spend it down and have proof of what you're spending it on. So I always say there's no such thing as hiding assets. You can put them appropriately in an ABLE account. You can put them in a special needs trust, but an UTMA and an UGMA account definitely can cause problems for you in the future. So if the person needs an iPhone, if they need a new computer, if they need medical care or expenses or medications or things, just so that you can prove that you spent the money. It's not a huge amount of money. So in that regard, so as long as you can either prove receipts or prove where it went, then you should be okay. We had an additional question that
Allison,
says how...
Can I say
yes.
add something to that? Let me just also comment on one thing that I've seen a lot. As most of us know, a 529 plan, the typical college plan, can be rolled over to an ABLE account. But the general rule, and a lot of times when people are getting on these government programs, the general rule to see if this is an asset for the individual who's going to be receiving SSI or Medicaid is, what could they convert to cash? Do they have ability to convert this asset to cash? And so a lot of times when we're applying, maybe there's some 529 plan out there that is not owned by the person who's going to be on SSI. But what we need to watch out for is what happens when the parent dies? Who is going to be the owner down the road, as Allison was mentioning. And I've seen situations where a parent has died and actually the owner became the person with disabilities, and they didn't know they had that resource for a long time, and then they get hit with an overpayment that's huge. So as you look at all these assets, look at who owns that now, what can be converted to cash by the person with disabilities, and then what's going to happen down the road. Is there some asset that's going to become owned by that person with disabilities? Make sure you don't set them up for a problem.
That's really good, Allison. I think a successor owner. So I want to comment on that. The 529C, and this is where there's some confusion. For the 529 for college, the 529 for college is in basically the parent or the grandparent's name, and the individual is the beneficiary. And the 529C is basically not going to be used against that person as long as the disbursements from that 529C are going directly to the college, right? Even if it's for the benefit of that person. But what you're saying is exactly right. So basically we're saying that if dad is the owner of the 529C for little Johnny, and then dad dies and the successor owner is Johnny, that's where it becomes a problem. And this is fixable. It's easily fixed by just simply having updating the successor owner. Requesting the form from your 529C company and updating the successor owner of who you want to be the successor owner of that plan. But the UGMA and the UTMAs are especially tricky. That's one of the issues, and because it does become the asset of the individual, it automatically becomes that. So that is the issue there. But the other thing, I lost my let me get back. I think that the other issue and confusion lies in the fact that the ABLE account is the owner of the ABLE account is the individual with the disability. It's not the parent. And so in that example, it is the owner. The owner is the individual with disability. So there's a few differences. So one question was, can I change the beneficiary you can change the owner and the beneficiary on the 529C. So the answer is yes to that. But if your student with a disability is the beneficiary on the 529C, you don't have to change that beneficiary because as long as it's used for higher learning, it's not going to be used against them if it goes directly to the college or the university. The other thing you can do is if you have a 529C, there is a such thing as converting to a 529A, and you can convert $16,000 a year. And the benefit of that is if you have a student with a disability that may or may not go to college, or maybe they're not going to college, what you can spend out of an ABLE account is if it can be construed as achieving a better life for an individual with a disability, you can spend that out of an ABLE account. Whereas if you spend other than for basic college expenses out of a 529C, then you're going to be taxed and penalized. So there's benefits to that, and we can certainly go deeper.
Yeah, Allison, I'm sorry to interrupt you. That also brings us back. We didn't finish answering a question earlier that was asked, what is a trust used for? So Allison was just mentioning the ABLE account pays for qualified disability expenses. The general rule for the special needs trust is whatever will benefit the individual with disabilities, whatever is beneficial to the beneficiary. And so what that means is the trust could pay for food and shelter, depending on the trust can definitely pay for the food and shelter as long as it's drafted to be allowed to do that. There just may be a financial impact depending on the government benefits that beneficiary has. So what I'm specifically referring to is if somebody is on SSI and the trust is paying for food and shelter, then it will reduce the benefits by 1/3. So instead of getting the $841 in a month, that will be reduced by 1/3 to $560. I have to look at my calculations, 2/3 of the $841. Now, there are ways around that. A lot of times trusts are drafted so that money can be moved from the trust account to the ABLE account, and then the ABLE account can pay for the food and shelter. And at that point, there's no reduction in benefits. But otherwise, the trust can pay for pretty much anything that the beneficiary wants, plane ticket, going on vacation, new clothing, new computer, a new refrigerator for the house, tickets to a show. And so it's up to the trustee to decide whether or not this is a good purchase. Should we spend all this money and buy a vehicle? Should we spend a ton of money and get a new house? And it's going to be up to the trustee to decide how that money is spent. The beneficiary doesn't get to go say, I want some cash, but has to tell the trustee, hey, this is what I'd like. And so that may have been a little confusing on the food and shelter. Again, I think there's a misunderstanding, and I've seen it written, that special needs trusts cannot pay for food and shelter. That's absolutely not true, but there may be a problem as far as, lowering the amount of some government benefit. But I will tell you, I would rather my daughter's living in a really nice place and getting a little less money on SSI. But again, most of the time we can work around that. And so it's not an issue. And when I say food and shelter, there's a big proposal to eliminate food as one of the areas we look at for in-kind support and maintenance, that penalty. So it's probably going to be shelter costs in the future. I don't know if that was a bit more confusing.
No, I think that is good. So I think, we've kind of talked about kind of some of the different roles that a special needs planner and advisor has, and I'm going to just move on to kind of some of the things. And we've kind of touched on, guardianship, special needs trust. We've kind of danced around some of those things. So talk to us a little bit more about you and the legal advice and the things that you prepare.
So, typically what I will do is I'll meet with a client and make sure we have a good idea of what the family needs. And we do typical estate planning documents, which would be wills and trusts, and very likely a special needs trust. We make sure we set up the right type of trust. Otherwise, we talk about guardianship. Some people clearly need a guardianship. Other people can have a less restrictive alternative, such as a power of attorney, supported decision-making agreement. So we just kind of look at all those different types of documents and court proceedings and see what's appropriate for your particular family.
So one of the things that we get questions about all the time, is if they know that they need guardianship, is it true that they can start that guardianship process 6 months prior to their child turning 18?
Yes, you can file a guardianship application 6 months before the 18th birthday, but you can't have the court hearing until the 18th birthday. There are a few exceptions. Some courts will let you sneak in a little early, and with good reason, most of them will let you get in a few days early. But the general rule is you have to wait till the 18th birthday to actually have the guardianship hearing. And that's because the court is making a determination that this individual is an incapacitated adult. So they need to be 18 to be an incapacitated adult. And along that line, someone could not sign a power of attorney until they are an adult and have legal capacity to sign it.
Sure. And for the families that are wondering or thinking, hey, we really don't want to take those rights away. Maybe my child's IQ is below 70, so maybe they don't have the understanding to sign a power of attorney or healthcare power of attorney. Can you talk about like partial guardianship and what your thoughts are on that? Because some families, they have fairly independent kids. Maybe their kids drive. They don't want to, they don't want to take some of those rights away. Is that a thing in Texas? And how do they have conversations about that?
Yeah, sure. Yes, there's a guardianship with limited authority or a partial guardianship, different terms for the same thing. And what that is the doctor fills out a form, talks to the parents, and it might be that the individual who needs a guardianship doesn't need a guardianship for every area of their life. And so the doctor can indicate, for example, I think this person should be allowed to vote. And then we file for a guardianship of limited authority, letting that individual keep their right to vote. Now, driving is another example. Now, I will caution you that, if you want your child to keep the right to get married, keep the right to make their own medical decisions, and you just want to have rights to maybe say where they live, the judge is going to look and say, if they have enough capacity to decide where they're going to get, if they want to get married, and if they can make their own medical decisions, then I think they can choose where they're going to live. So, sometimes you can't just pick and choose. It has to make sense logically that this is the right type of guardianship. But absolutely, we don't want to take rights away from someone unnecessarily. And so if your child needs a guardianship but has the capacity to do some of the things that they want to do, you can let them keep their rights. But again, this has to be supported by a medical documentation in a physician's certificate of medical examination. It's not enough.
I wanted to ask you, Allison, who decides? Is the judge, the parents, but it has to be supported with a medical paperwork saying that this person is incapacitated to have that full guardianship for the parents.
Yes.
Or it always is the parent, right? It could be another person, the guardian.
That's right. So a guardianship hearing kind of has two parts. One, is there a medical need for a guardianship? Is this person really an incapacitated adult? And then the second part is, who's the right guardian? So getting back to that determination of incapacity, the judge needs some medical evidence. And there's a set form that the doctor fills out. And on that form, the doctor will say whether or not this person should retain this right or not. Do they have the ability to make their own medical decisions, to drive, to vote, those kinds of things? Yes or no. So it really comes down to what the doctor says, but hopefully you as a parent are communicating with the doctor and explaining, this is why I think my child can vote. Well, voting, most judges will let someone keep the right to vote if it's important to the family. But, you'd want to work with the doctor and say, this is why I think my child should keep this right. This is why I think they're capable of it. So it's not like you just hand it over to the doctor and hope they say the right thing. But as far the judge makes the final decision, but the judge is going to rely very heavily on what the doctor
says.
Mm-hmm. Yes.
Got it.
So I have a question. And again, like these are some of the topics that we're talking about, like the guardianship and the special needs trust and things like that, where we have entire webinars on those specific topics. But one person said, how do you prevent banking deceptions or frauds against disabled people, especially against young people with mental health problems? And that's a great question, because there is a lot of deception in that regard, and we've also seen a lot of individuals with disabilities that may be really great on one side of the house, but they have zero ability to handle finances, like none. So what do you think about that, Allison? How do you address that? It's a great question. Thank you for asking.
It is a great question. If the capacity is so limited, then it's obvious, that they need support, that there's just no way that they can make decisions, that they're clearly incapacitated, then a guardianship is going to make any transaction void. If they're under a guardianship, then the court is going to issue an order that says this person cannot make these decisions. Therefore, if they sign something, it's just void, and you can, go after the person if they knew there was a guardianship, or they can void whatever happened. But as far as if you were to say, my child doesn't need a guardianship, I think they have the ability to sign a power of attorney, I think they have that capacity, I don't want to take away their rights, then you are indicating that they have some capacity. And so if they go sign something they shouldn't sign, they sign up for a gym membership, or they sign up for this, you can try to go back and argue that this was limited capacity, but it is a tough road. So I think we need to all spend a lot of time talking to our kids with that borderline capacity, really working with them so they don't do something crazy. And then I would encourage your child to consider a supported decision-making agreement. And that's an agreement where the child still has rights to make their own decision, but they get to have a supporter come in and give counsel, help communicate, and just be there as a sounding board. But that does not give you as a parent the right to take over and make decisions. A supported decision-making agreement, you're just the supporter. So I think there's still got to be a lot of training with our kids, explaining that, you got to be careful, don't sign something, always talk to me if you need some advice, that type of thing. I don't know if that was a great answer, but Allison, I don't know, maybe you have better advice.
No, I think for sure. And I think, we see joint accounts, with a parent on the account. And, there's other things. I mean, once they turn 18, if you don't have something in place, and then it can be problematic, and then they mess their credit up, they mess all kinds of things up. So, and of course there's, there's fraud beyond messing it up and not having understanding of financial instruments. I mean, there's certainly things such as fraud and things like that happen. One question that we had earlier, it was on the UTMA and UGMA accounts. and they're saying that the kid is almost 17, almost 18, okay to leave it for now, I would get it gone before 18 because it is going to be counted against them basically. So I would work on spending it down, moving it to an ABLE account, or moving it to a trust. Then we had,
yeah,
is
Allison,
it okay? Yes.
Oh, go ahead. No, go ahead, finish your question. I'll come back.
I was going to say, we had a question on, is it okay for a paycheck to go to an ABLE account? Yes, and it's okay to move SSI or SSDI proceeds. You get a back pay. It's okay to move those to an ABLE account. You just have to you have to be under the maximum of $16,000 a year unless the kid's working, and then you have the additional amount.
Yeah, that's right. But don't forget, even if you're having the paycheck go, you can't make income disappear by having it go to the ABLE account. The ABLE account makes the total amount of resource not count if it's under 100,000 or higher if it's Medicaid only, but the income still counts. In other words, whether your paycheck is going right into the ABLE account or something else, it's still income for the beneficiary. That's
a great point. And what that means is if they're getting SSI, so let's suggest that they're getting $841 a month on SSI, they're working, their paycheck is $500 gross for the month. So basically what's going to happen is you're going to have a reduction in the SSI, and it's going to be $500. They don't count the first $85. So that goes to $415 divided by 2. And that is the amount that your SSI check is going to be reduced. So in the example of earnings. So that's a great point. No such thing as hiding the earnings. You still have to report the earnings even if they go to the ABLE account. It's that $2,000 limit that we're putting money into the ABLE account to stay below that $2,000.
Yeah, and if I could just go back a couple questions, I meant to add this and forgot until after I quit speaking. But on a child who's receiving SSI or childhood disability benefits or some kind of SSDI, then there is the great option of someone becoming a representative payee, and that is basically a guardian for Social Security money. And so, just for that particular money. And so that means that I'm my daughter's representative payee, so I can go open up a bank account for my daughter. I can manage the funds in there. I don't need a guardianship from the court to do that. I just had to work with the Social Security Administration, explain that my daughter can't manage money. Very easy to do, but that also helps a lot. So sorry, backing up a couple questions, but didn't want to forget to mention that.
Sure. Let's see here. Okay, so some additional things that you do, and I think we've kind of been hitting on this. You're going to spend time talking to people about their personal circumstances in relation to some of these topics that we're talking about. Do you want to hit on this?
Hit on what exactly what I'm going to do in the interview? Is that what you're saying?
Yes, kind of as far as like we were kind of talking about guardianships, alternative to guardianship, power of attorney, healthcare power of attorney. Like Allison's going to be able to talk to you about that, talk to you about your child, and really talk to you what might be the best path. Is that right?
That's right. Yeah. And sorry, I was a little clueless where we're going. Yes. So what I would do is if we're talking about guardianship and alternatives to guardianship, we would talk about the level of capacity that your child has, try to figure out what the best plan is. Do they need to have a full guardianship, or is there a chance that they could go ahead and sign a power of attorney, understand what they're signing? Would a supported decision-making agreement be proper? And if so, then we'll talk about, if it's a guardianship, what limits should there be? And then we'll talk about that process. As far as the trust, what I would talk to you about once you said, I want to get a special needs trust, I'd make sure to explain the difference between a first party trust and a third party trust. So you knew that you would never put your child's own money in a third party special needs trust. We talk about the Medicaid payback and things like that. And then I would spend quite a bit of time with you talking about the details of your special needs trust. What do you want this to pay for you for your child? Are there, do we want to give instructions to the trustee of how this money should be spent? If you don't give instructions, it's up to the trustee's discretion. But some families like to give instructions. I want my child to be able to go on a vacation once a year. I want this trust to pay for relatives to come fly in to see my child, but not the spouse, not the children. Or I wanted this money invested invested conservatively or not conservatively. So we can get into details of how you want the trust to be managed. And so those are the types of things we talk about, and then review documents together. And there's always lots of questions and lots of interplay about government benefits and other family dynamics.
For sure. And one question that we had, Allison, was, do all of these decisions have to be made prior to 18? And the answer is no. I mean, you don't have to have, you don't have to start the guardianship process 6 months prior to the child turning 18 and file the papers on their 18th birthday. And if you're late or you haven't decided or you're still, I use the word still evaluating, a lot of people that we talk to every week, we hear, I'm hopeful and optimistic. We're not quite there yet. But I'm hopeful that one day that my child will be semi-independent or independent, those types of things. So if you're feeling like you're late, you're not too late and you can go back. So talk about that, Allison.
Yeah, I absolutely agree with that. My daughter's 27 and I do this professionally. I think about these issues all the time, and it is still a big work in progress in our home, trying to figure out the long-term plan for her. Do we leave a house? Do we have her live with her brother? Do we, how much money is she going to need? Are there going to be government programs out there? It's a constant reevaluation. So there's no easy way to just get it all done, whether you're 18, your child's 18 or 21 or 30. You always sort of have to be reevaluating, what's going on as far as the world of government benefits and in your own personal life, and quite frankly with your other kids. And anyway, it's something where we have to always be thinking about that plan. I tell my clients, when a normal family without a child with special needs, I guess there's no such thing as a normal family, but when a family comes in and they don't have kids with disabilities, they tend to leave and they have their wills and other estate planning documents in place and they celebrate and they don't even think about it. Our families, when we have kids with special needs, we have to maybe reevaluate every 2-3 years and see where we are. Is this still the plan that we want? And that's why it's great to have contacts with Allison and other people to sort of touch on this again. But, it's a tough thing. And if you don't have it all worked out, you are not alone. And it's fine. Just start where you are. Start making a plan for what you think is right now. And that plan may change. And that's something about special needs trust. You can make your special needs trust, if it's a third-party trust, make it be revocable and completely changeable until your death or the second parent to die. So we talk about those kinds of issues. So you're not locked into a plan. You can change it. A first-party trust does need to be irrevocable, but anyway, there's lots of ways to change your wills, change your trust over the years if you need to.
And I'm kind of a fan of, it's not about looking back about what you haven't done or what you haven't checked off the list. You are where you are. You're here right now, and it's about moving forward. It's about reviewing what have you done, what do you already have in place. What do you need to check? What do you need to fix? We oftentimes spend time talking to clients and reviewing documents, reviewing specific beneficiary designations, because there's a big misnomer out there that basically if you have a will or you have a trust, that everything just goes according to the will or to the trust. And the thing is life insurance, any things where you can have like a designated beneficiary, the beneficiary basically trumps everything. So if you did something on documents over here but didn't correct your beneficiary designations over there, we see mistakes on that. But one of the biggest mistakes that we see, Allison, on a pretty regular basis is where families are naming their kids, their minor children beneficiaries, regardless of their disabilities. Or we also see where people are naming their special needs child outright as a beneficiary. And so we don't ever want to do that. That's the whole point of having that special needs trust. So that way we can leave the beneficiary, the supplemental needs trust for the benefit of Johnny as opposed to Johnny outright, right? Because when it goes to Johnny outright, then you basically need to hire an attorney and you need to get that money put into a first-party special needs trust that now has a Medicaid payback. So there's some steps that we can take along the way that are going to streamline things. They're going to have money in the right buckets. They're going to prevent a Medicaid payback. And there's a lot of things that you can do, like just simply, if you're taking notes today, take a note of saying, let's check my beneficiaries, my primary beneficiaries, my contingent beneficiaries on everything I own: life insurance, bank accounts, 401ks, 403bs, old pension plans from an employer you left 10 years ago. Those are all good places to double check that, because we just see mistakes on that every single week.
I totally agree with that. I really support that. It's a big issue. And let me just also put a plug out there for anyone who's got teacher retirement benefits. Look into those benefits. We can usually keep your child receiving some kind of program benefits, such as Medicaid waiver programs, by moving money that was received directly into a first party trust, as Allison recommended. But there are some things we can't fix. And we have lots of problems with teacher retirement system. Once you're gone, I can't do anything about an annuity payment that's coming every month. And so really look at, as Allison mentioned, all of those beneficiary designations. You don't want to have a first party trust unnecessarily. We want it all directed to the third party trust. So that is great advice.
Can we talk about, we had somebody in the chat box, and this is kind of like, do you say tomato or tomato or potato? Should it be, irrevocable or revocable when it comes to the third party trust? I think it is a matter of preference, and I've seen it all across the board for both ways. But can you talk about that question?
Yeah, I don't have a set answer. I think that's going to be really specific to your situation. If I'm dealing with a very young couple, there's a lot of things up in the air, where the money should go when the person with disabilities passes, who the trustees should be, how the money should be spent. I typically will recommend keeping it revocable, so it's very easy to make changes over the years. Sometimes an irrevocable trust is better if we're really concerned about some creditor issues, or if we just feel confident enough that this is a set trust and maybe somebody else, a grandparent, wants to pay into that trust, they may want that to be irrevocable. If grandma is leaving money to my daughter, she may not like it if I pass away and my husband remarries and can change all the terms of the trust to leave it to his new wife or his new stepkids or something. That's a bad example. But anyway, you get what I mean. Sometimes irrevocable is the best way to go. Sometimes revocable is preferred. If it's a first party trust, we don't have a choice. It's irrevocable. But we would talk about all those issues depending on your specific family situation.
And I think the biggest thing that I've seen is where we've had parents or grandparents that were, like leaving large sums of money where they wanted it irrevocable. So I agree with that. That's typically where we have seen that. And the truth is, there's all kinds of, and this is why you want to work with a professional such as Allison, or someone else in your area as it relates to special needs. But there's all kinds of language that can be put in there. It's about it being written correctly. There can be such thing as a trust protector. So because someone mentioned about individuals with disability being taken advantage of, or misappropriation of funds and things like that, there can be such things as trust protector, things like that. And so the thing is what I recommend, we typically say about every 3 to 5 years. We want you to have your documents looked at. And as Allison said, things change. But you know what? It's not just with our special needs children. Our lives change. People buy houses, they sell houses, they get married, they get divorced, people die, people change jobs and have changing in benefits and things like that. So situations change, kids grow up and are out of college, out of the house and things like that. So just looking at this from time to time and not waiting until you're in crisis, till somebody's been diagnosed with something horrible and you're getting ready to go in to have surgery or something. We do see that as well, like where, something happens and then it's like we move into crisis mode. So we look at these documents, but also the laws change, so there are updates to the law. There is updates with the Social Security Administration and things like that. So definitely if you've had documents that were drafted 10 or 15 or 20 years ago, I would say it's definitely time to be reviewed. And I don't think that means that whoever you go to is going to ball them up, throw them away, tell you that they're horrible and we have to start over. Sometimes that is the case. Sometimes it's just easier to start over because they're so outdated. But there's amendments and other things that you can do. Is that right, Allison? If somebody needs like an update, how does that work?
Yeah, you can do an amendment to your trust. If you've already done your beneficiary designations and everything's going to that trust, we would typically advise an amendment. Even if it's irrevocable, we can go to court if necessary, but we can do amendments to trust. And if you haven't directed your assets to that trust, we might just draft a new one. Wills, same thing. You can do a codicil to the will, or you can just draft an entirely new will. So yeah, we can always make adjustments as needed.
So I think that's the key. If you have documents that you haven't looked at in a long time, if you have guardianship and you have moved to Texas from out of state, if you have guardianship and you have moved from one county to a new county, you need to talk to an attorney about that as far as the guardianship is concerned. But just having, a professional set of eyes look at your documents and make sure that everything is set up, correctly will prevent those Medicaid paybacks in some regards. The very last thing, and we're about out of time, but one thing I know is near and dear to my heart and yours too, Allison. One of the huge things that we see mistakes happen when we have kids that are turning 18 in divorce situations where child support is going to continue post age 18. That's a big thing about having that child support redirected to a first party special needs trust, or otherwise that child support is going to be counted as income to the child who is applying for SSI and Medicaid. So do you want to, I know we just have just a few seconds to wrap up, but I want you to hit on this because this is a big issue.
Yeah, a quick summary of that is if you have lifetime child support, the child support, once the child is 18, will count dollar for dollar as income for your child with disabilities. When they're under 18, there's a 2/3 calculation. It's complicated based on several things. But once your child is over the age of 18, it is dollar for dollar, which means if there's $500 in child support, that will reduce an SSI benefit by $500. If it's too much, it might completely eliminate the benefit. The way to get around that is a court order ordering the assignment, or rather the creation of a special needs trust and the assignment of the child support to that trust must be done by court order. You can't just move your funds into the new trust, and it has to be a first party special needs trust with a Medicaid payback on it.
So the bottom line is if you have child support, the easiest way to go about this is asking the person that's paying the child support if they have any objections to it being redirected to a first party special needs trust. Basically, if they don't, an attorney can draw that up and get that signed off on by a judge. Of course, you have to have the first party special needs trust. But in the example that you don't have a cooperative party that's paying the child support that's willing to just sign off on that, can you just quickly kind of say how does that go? Do you just hire an attorney and petition the courts to get it redirected?
You go back to family court and you're going to win. But honestly, it's a no-brainer. Everyone should be signing agreed orders. It is good for everyone to have the child support going to a special needs trust. The parent who's paying, it's going to help them. It's going to allow our kids tap into childhood disability benefits down the road, which is going to end up reducing child support for the person who's paying. Maybe that's a complicated analysis, but the short version is everyone really should agree to this. And if you have to have a lawyer and go to court, you're going to win because it's a no-brainer to have this happen.
We have one last question and then we got to wrap up because we're over time. This question is for you, Allison. If you have a will from another state, will it be necessary to redo the entire will, or can you amend the will in Texas?
You're probably going to want to just draft a new will. Wills are not that expensive to draft. And there's certain language in Texas that makes a probate proceeding much easier. We're looking for mention of an independent executor rather than some of the language used out of state. I would just say have your will reviewed by an attorney. It might be completely fine, but you might want to redraft it to make the probate process go much more smoothly and save money on that end.
Thanks everyone for being here and joining us today. We hope you feel empowered. We're glad you're here. We're here to answer questions. You can reach out to us directly. I'm happy to chat with you if you had additional questions that didn't get answered. And Veronica, thank you always for having us, and it's certainly our pleasure. And Allison, thanks for joining us today. Glad to be back with you again.
Thank you all so much.
Thank you. Bye.
Take care, everyone.
Bye-bye.